OK。
It's the appointed time and we have a quorum. Item number 1, confirmation of minutes of meeting. The minutes of meeting held on the 22nd of October. It's been given to members and the Secretariat has not received any proposals for amendment. I ask members to confirm the minutes of meeting. Mr. Wong Ting Kwong? Thank you. Item number 2, information paper issued since last meeting. There are 2. The first one is administration's paper on proposed adjustment to fees and charges under the purview of the Trade and Industry Department. Paper CB1394/13-14(01). It's a reduction of fees. Is that right? The second paper, administration's paper on Hong Kong Shenzhen Corporation meeting. Paper number CB-1530/13-14(01). Item number 3, dates of next meeting and items for discussion. For the regular meeting in January, well, on the 15th of January, the Chief Executive will deliver his policy address. Our next regular meeting will be on the 21st of January, which is a Tuesday, at 2:30 in the afternoon. It will be a briefing on relevant policy initiatives featuring in the Chief Executive policy address. Item number 4, treatment of parody, public consultation on treatment of parody under the copyright regime. Let's invite the administration to join us.
首先歡迎政府當局嘅代表出席。
Let me welcome government officials. We have Mr. Andrew Wong, Permanent Secretary for Commerce and Economic Development, Commerce, Industry and Tourism. Mr. David Wong, Deputy Secretary for Commerce and Economic Development. And Ms. Patricia So, Principal Assistant Secretary for Commerce and Economic Development. Ms. Ada Leung, Deputy Director of Intellectual Property, and Ms. Michelle Chong, Assistant Director of Intellectual Property Copyright. It was a 4-month public consultation. Now we have the result. Would you like to take us through the paper, Permanent Secretary? I thank the Chairman for letting us revert to you about this topic today, because we would like to explain to members the result of the public consultation. Between the 11th of July and the 15th of November this year, we had a public consultation on treatment of parody under the copyright regime with regard to present-day circumstances and to treat parody as appropriate. On the 11th of we have already explained to members about this consultation, and we had a public hearing on the 4th of November. We have proposed 3 options that are not mutually exclusive. First, a clarification of criminal liability and to to clarify the criminal exemption. That is the second option. And option 3, fair dealing exception. And I would like to present to you the result of our public consultation. We have received 2,455 written submissions. Users and Internet group accounts for 2,387, out of which 2,100 of them are templates, or templates that are changed slightly from copyright owners groups 43, online service providers 7, the rest 18 came from other individuals and organizations, including the academia and legal profession legal professional organizations. Online users obviously support the expansion of the consultation on secondary creation, and they advocate a full freedom of expression. Some people think that the consultation proposal will restrict civil rights, and they ask the consultation to be withdrawn. We've done our best to explain the purpose of the consultation, which is to set out 3 proposals of the treatment of parody under the regime. There are respective legal bases for the 3 options to afford better protection. On the other hand, copyright owners think that a sound copyright protection regime is very important in creating a conducive environment for creative activities, and they ask for the current regime to be updated. Some copyright owners say that there has never been any criminal or civil proceedings against parody, so there is no need to provide exemptions for parody that would in other ways replace the original work. So some copyright owners prefer option 1, that is to clarify the existing criminal liability, while some agrees with option 2, that is to set down criminal exemption of parody. They think that it should be restricted to non-commercial parody and not on satire, caricature and pastiche, because the scope will be too wide. Some internet users in general prefer option 3, which is fair dealing exception. At the same time, there are some views saying that it should be further extended to secondary creation and user-generated content, UGC. User groups and representatives of the copyright sector submitted submissions, and there are 2 new ideas on the amendment. You will find the details in the document, and they are other views on top of the 3 options. And we have also given our views or preliminary views on all these new proposals. There may be divergent views, but we are aware that there is a consensus between users and copyright owners. They do not want to infringe on the legitimate right of the other party. And they think that the guiding principle of the consultation should be adopted. That is, the final proposal should strike a balance between the interests of different parties and to make sure that Hong Kong will fulfill its international obligation. On this issue, we are aware that there are divergent views, and we would like to make use of the coming few months to further consider the various views. We will continue to liaise with various stakeholders, including users and copyright owners. Hopefully, we will collate the views and start on our drafting. Depending on the progress, we will decide on the way forward, and as soon as possible, what we started in 2006, that is the updating of a copyright regime in response to changes in the technological environment. There are 5 members who would like to ask questions. Perhaps we will set the time at 4 minutes. First, Ms. Claudia Mo. Thank you. I'm not a member, and I thank you for letting me speak. Well, we're talking about copyright protection and intellectual property. Basically, I don't have any problem with it. The problem nowadays is the concern of the narrowing down of freedom of speech on the internet. And I think there are some difficulties. Well, for the stalking legislation, it's plucked out of thin air. For this copyright regime, we already have an existing copyright ordinance. If something happens, you will be arrested and prosecuted. So the amendment itself is very difficult. Let's first leave those on the internet. Intellectual property itself. Say, for example, well, there is an alteration of Gone with the Wind. The court thinks that, well, it's a fresh creation, but some other people think that it is an alteration. Catcher in the Rye. And the court said, no, this is infringement. So you are worried that during different times, in different courts, there may be different interpretation and different rulings. So I'm happy to hear that in general copyright owners say that, well, first of all, it should not be for profit making or commercial purpose. Secondly, it is parody, and thirdly, they only want to target piracy on the internet, because in this way they suffer losses. Well, internet users come up with a fourth proposal, a fourth option. Of course, I know that you're going to say that you don't have a preconceived stance because the views are quite polarized. It's been 4 months, and everyone is saying what they want to say. What about the middle ground? How do you find the middle ground? My prime concern is that copyright owners will say that they will not give up their right to civil claim. Well, that will be the sword of Damocles. So at this stage, when it comes to a civil liability, does it concern you? Perhaps I will try to answer. At the beginning, I said that we still need time to liaise with relevant stakeholders. In the paper submitted to the panel this time, well, Ms. Mo said that some internet user groups come up with a fourth option. In Annex 3 of our paper and the relevant annexes, we have given our preliminary views on this option. Of course, in Canada, they cited the Canadian example. About a year ago, there is a special exemption legislated in Canada. And in Canada itself, it has attracted many different views. So we need time to talk to the relevant academics and the proponents. May I ask one more question? What about the timetable? When will you be able to complete everything and come up with a final proposal? Well, if I can come up with a widely accepted proposal, I will start my work the day after. But as I said, I hope that we will use the coming few months to talk to stakeholders. If we can arrive at a generally acceptable proposal, then we will be quite certain that we will come back to the electrical for the introduction.
Mr. Ma Feng-Guang. Thank you, Chair. Now, the government paper informs us about the consultation, but then we also read from the papers that the government will conduct informal consultations. Now, I'd like to know more about how you want to go about that. Secondly, the progress for your legislative timetable. When are you going to get your draft ready and be given to LegCo? Now, of course, you have to strike the right balance. The owners of the copyright, is to be protected, and then the creation again is, or creativity is to be safeguarded. Now you've got a fourth option from the netizens, but it may not fulfill the three criteria. Now if that is the case, then at the end of the day, how can you convince the stakeholders that that option is not the way to go? So these are my questions. Chair, now first of all, we had 4 months of consultation, and colleagues and myself have been to different forums and have met with different stakeholders. Now, Mr. Ma, your question about whether we will continue with consultation is not a new round of consultation, but with stakeholders such as copyright owners, internet users. We have been in touch with them, and we hope that with our continuous conversation with them, we can understand our concerns more. Now, and this is related to your last question, that is our view towards option 4. If it works or if it doesn't work, how can we give an explanation? Now, what I want to achieve most is, now in past consultations, we have understood people's concerns more. So it's not whether it's going to be any one of the options or even options 5, 6, or 7, but rather we look at what stakeholders are concerned about most and how these can be achieved within the existing legislative framework. Now, of course, if there are acts or behaviors which are infringement of other people's rights, then we can only explain to people that this is infringement of other people's rights. Now, but then under existing legislation, we have given a certain level of protection, and these again have to be relayed to stakeholders. And this is something we're going to do in the next few months. Now, for timetable, now we have to discuss first before we can talk about amendment of legislation. So that order has to be followed. Now, the 3 options we raised, for each of them, if it entails amendment, we would know how to make amendments. Now, unless the option to come is going to be very, very complex, otherwise we are pretty confident as to how to go about with the amendment. It's not like doing everything all over again. But then we have to decide what needs to change and what does not need to be changed. And we have to again discuss, first of all, with the users and then the copyright owners before we can talk about timetable. Mr. Mok Lai Guang. Now, after this round of consultation, you have given us a kind of conclusion. I think that's pretty quick, and I gauge from this that you want to expedite the issue as well. Now, to summarize, I have to say that the consultation was done in pretty good atmosphere, and colleagues have been working rather hard, and those of us who have been there, well, sometimes 4 or 5 times, and you have explained the issue very clearly, and talking to both sides, well, mainly both sides, and I have seen better communication. Now, if you look at the summary stance, I mean, the stance remains pretty much the same. And if you look at the details, I mean, there might be changes, but it seems that options 2 and 3 are more acceptable. Now, in the past, the 2 options were not quite accepted. Now, for option 3, some users wanted to well, to suggest option 4, but they are more amenable to accepting. So it's not just the status quo being kept. Now, I think I have sensed some improvement. Now, but then I don't want to see ourselves, well, not moving forward. And we should continue. And the legislation is not meant to handle parody. Now, obviously, the public is concerned about this, but we want to tackle infringement of copyright. And some stakeholders do not want to wait, and there might be pressure from international stakeholders. But I believe similar questions will be asked, but you are not really answering those questions. Now, you have told us that you have talked to the various stakeholders, mainly the two parties, and you are, well, negotiating, discussing. But what exactly do you mean? Are you discussing with them openly? And then you haven't told us anything about timetable, and you haven't told us what is going to be done if they do not come to a consensus. You have told us that if there's a consensus, you know how to do. But then what about if there is no consensus? Now, I hope you can tell us something substantial. Now, going back to this consultation, okay, the progress has been made and is much better than the worst case scenario. Now, if you are not able to answer questions such as how and when to progress, now we are going to be disappointed. Now, is there anything you can do? Are you going to come back again in 2 or 3 months' time that you have finished discussing and that you have made up your mind? Now, is that the case, Chairman? Now, Chair, I believe the most difficult question to answer today is going to be timetable. If I do have one, I'm going to tell you. But the good thing about not having a timetable is that we are demonstrating our sincerity to the stakeholders, that we really want to find a solution. I share Mr. Mok Lai Guang's concern that this is something we have to do. We have to amend the copyright legislation, because in common law jurisdictions, this is something very important. We have to make the amendment, and we are determined to do that. But that said, we must strive to get the biggest extent of consensus. The only thing I can promise is whether we are making any progress or not. Now, 2 or 3 months' time, we'll come back and let you know. So this is the only timetable we have. Mr. Sin Chung Kai. Now, I think the Secretary and your colleagues, your consultation, your round of consultation has been pretty good, and demonstrating very high EQs and also being very meticulous. Now, this is a good thing. I hope you will continue with this working attitude. Now, however, I am not optimistic about any consensus being reached. I think the issue is very, very diversified, and whether you are talking with the government or LegCo, we have to make a decision that would satisfy nobody. No one would get completely what he or she wants. I think to legislate is very often to strike a right balance between the two groups of stakeholders, because we are not playing on an unlevel playing field. Now, if we cannot come to a consensus, and at the end of the day you have to come to LegCo, of course we want you to sort everything out before coming to us. But I agree, I mean, the best scenario may not necessarily be achieved. And this is a pretty tough one, and you cannot really get 100%. Even achieving 70% is hard to obtain. Now, this round of consultation is for the exemption users. In fact, the longer you drag on, the more they will be affected. So not making any progress is not a good thing. Now, I don't want to repeat the question about timetable, but after you have done your basic motions, say you've got 80% consensus, then you would have to follow the procedure and come to us, and then we would have to decide where to draw the line. Now, the EU has made some progress. Is this the case why you have made some comment on the UGC, the user-generated creations, content? Now, Chair, I agree with Mr. Sin in that a one-off consultation cannot handle all the controversies regarding copyright. I'm sure Mr. Sin knows better than myself. In the past, you have taken part in copyright changes and amendments, and this calls for regular amendments. Now, in our paper submitted to you, now there are many topics raised. It may not be the case that we can solve all the topics at one go. We've made it clear that this is not really our goal. It is something that has to be done on a long-term basis. We will have to come back to you regularly. As Mrs. Sin said, now apart from the Canada situation, where you have the concept of user-generated content, now in the EU they have started the same consultation on the same concept, exactly the same concept. Now, there's only one country, Canada, which has legislation on this particular area. But the trend, if you look at the international trend, it's difficult to say. Maybe 3, 5, or 7 years from now, there might well be changes. Now, for this round of exercise, we may not be able to solve all the problems. Now, maybe I defer to my colleague to say a few things, if I may. Now, Mr. Sin's point about the development in EU, we also looked at other parts of the world on how we protect internet users and to prevent internet piracies. In our Annex 3, the last bit, paragraph 18, we've discussed the issue of Ireland, and they've got a latest report whether they should follow in the footsteps of Canada regarding the exemptions for the UGCs. But this is only a very initial review, not a definitive one. Now for Australia, now early this year in May, they have considered, their Law Reform Commission has considered whether new exemptions should be created, particularly the use of derivative works, digital creations, whether these can be exempted. But then that was basically ruled out.
The study continues as far as we know. We know that there will be further reports to be published. On the 5th of December for the European Union, there is a public consultation. So it's just started. It mentions about a series of issues including UGC. This is not the first time when similar studies has been done. For quite some time in recent years, they have been doing studies on this issue, and so far there are no conclusions drawn. And when it comes to UGC and the copyright issues related, the preliminary observation is that there is no consensus, not even on what problems there are. We keep in mind the international trend when we're doing our work. Next, Mr. Dennis Kwok. Thank you. I also want to talk about legal concepts. UGC has been covered by a number of members. I'm not going to repeat. I just ask the administration to actively consider UGC. So don't close the door too quickly. When it comes to the legal concept, I see the submission of the Bar Association. It's commenting on current affairs. So then perhaps should be a fair dealing exception. I have reservations, because exemption in this way, or a fair dealing exception, in effect narrows down option 3. Because option 3 itself is wider, because it doesn't restrict, it's not limited to current affairs comments. So when it comes to the Bar Association comment, is it just on a fair dealing exception? Indeed, what Mr. Kwok said is right in relation to the comment of the Bar Association, but the scope of the fair dealing in the submission is narrower than the scope under option 3. But they are not groundless, they said very clearly in their submission, that commenting on current events should be exempted because there is an element of public policy involved. We've always talked about copyright or intellectual property. It is a right. The right should not be narrowed without good reason. Say, for example, freedom of expression. If you want to narrow down one's freedom of expression, you will have to have a very good public policy reason. Now we talk about copyright. If the right is to be affected, my interpretation of the Bar Association comment is that when it comes to commenting on current affairs, there should be sufficient public policy reason for you to affect someone's right. So the polarized views boils down to this. If there is no exemption in whatever form, whether it is UGC or fair dealing or criminal exemption, what is the scope? If it's UGC, practically anything generated by you is exempted. And according to the Bar Association, why should an exemption, whatever the scope, should be given in the first place? Parody, fair dealing are proposals we made in the consultation. So whether it's a parody or parody plus the other 3, there are many different views. Some people think that it should only be applied to parody while excluding satire, caricature and pastiche. And the Bar Association think that all 4 should be included in the fair dealing exception. Well, Mr. Kwok. Well, the Bar Association mentions commenting on current affairs because they're concerned that it's difficult to define a parody or caricature. But according to the 2006 Australian case, definition itself is not a problem. when we look at the work, we'll know whether it is parody. So I don't agree with the view of the Bar Association. Next, Mr. Martin Liu. I don't have to criticize him. The permanent secretary admitted that we are lacking in our copyright regime. The amendment to the copyright ordinance has been dragging on for too long. I don't know whether it's because it's something good. Of course, it will be met with obstacles. It doesn't come easy. There is still a big gap between two major groups. Even for the two legal professional groups, the views are quite divergent. I support further consultation, formal or not, hoping to bring the two groups together and to narrow down the difference. And please do not waste too much time. And do not waste time on radical and extreme views. A consultation should be built on rational discussion. And I don't think the Bureau Secretary should think about a consensus, because that will be his own wishful thinking. We need to listen to the public, but we should not be populistic, because protection of intellectual property is very important. There should be a reasonable balance struck between that and freedom of expression. And don't forget that there is a policy in your bureau to promote Hong Kong as an intellectual property trading hub. If legislation does not afford sufficient protection, then it will only remain a dream. I fully agree with what the legislator said. On one hand, we would like to promote Hong Kong as an IP intellectual property trading hub. And recently, through the relevant working groups, we have formulated a framework. One of the important elements under this framework is to have a robust copyright protection regime. So I agree with the member that on the copyright amendment or copyright regime, we are lagging behind compared to our competitors. But I will not drag my feet. I hope members will understand. As we've explained in the document, when it comes to parody itself, there are many different views. It's impossible, as the member said, that for us to take into account extreme views, i.e. no regulation whatsoever. But we would like to explain as far as we can and dispel users' concern, especially on areas when under the existing legislation there is a certain degree of protection. Still, we have to engage them in further discussion. Copyright owners have softened compared to their previous stance, but it takes time. Some of them are still of the view that exemptions should not be given too much. Mr. Wong Ting Kwong. Thank you, Chairman. Users vis-à-vis copyright owners. Well, I think you can't please everyone when it comes to the legislative amendment, and there is also a political element involved. The focus is on parody now. Appendix 3 points out that when it comes to UGC exemption, it does not help us fulfill our international obligation when it comes to copyright copyright protection, have you sought the views of the Department of Justice, DOJ, or is it just a conclusion drawn from your common sense? Can the administration explain to us that if you adopt UGC, and if it violates our international obligation of copyright protection, well, Hong Kong will be held responsible? Mr. Wang, when it comes to the international obligations, well, we have lawyers in the IPD, Intellectual Property Development, and we have the assistant director here with us. In Appendix 3, you will find information related to the Canadian UGC exception. Indeed, there are different views in the legislative process. We have set out the different views expressed in the Canadian exercise. Well, whether it is fully compliant with international agreement depends on whether someone will take out litigation in the World Trade Organization that it is not compliant with international agreement. When it comes to the three-step test requirement, we will see whether we will see from the three-step test a final decision, and under the WTO there is a tribunal that decides. Unless a member state takes this to the tribunal, we will not get a result. And Appendix 3 sets out the various views expressed, and I would refer to the assistant director, or the deputy director. On one hand, we look into the Canadian exercise, whether some academics or some authority have expressed any views. We have conducted some preliminary analysis because of a shortage of time. We see that there is a case in the WTO about the interpretation of the three-step test requirement. You'll find the analysis in paragraph 15. Is a dispute resolution case between the US and the European Union. You'll find information about the interpretation of the experts of the WTO on the three-step test. The first test is whether the exemption relates to a special case. And whether it is a special case, the scope is rather narrow, that there will be an exceptional and apparent purpose. The experts looking at the Canadian legislation thinks that the UGC itself, if it is a copyrighted work, then it doesn't show that it is conspicuous. This is conspicuous, important, or unique enough. And when it comes to whether there is any conflict with the copyrighted work, some experts think that if A uses the exception and B uses the exception to generate some user UGC, what is the overall impact on the original copyrighted work?
That is whether it will conflict with the normal exploitation of the work. And not enough emphasis is given to the derived products. So let's say you start off with a novel and now made into a movie. So the movie is a derivative or derived work. So will that market or potential market be affected. And it seems that the Canadian option does not deal with that satisfactorily. Now, the third step, whether it unreasonably prejudices the legitimate interests of the copyright owner or author. This is similar to the second step. If it conflicts with the normal exploitation of the work, then it will also unreasonably prejudice the legitimate interest or financial interests of the owner of the copyright. Now, so in this regard, the experts are querying the three steps. Now, for the fourth option, now we have looked at Appendix A and compare the Canadian situation with option 4. Now, option 4 is even looser than the Canadian legislation. For the Canadian situation, the UGC has to be a new thing, but option 4 would allow even derived work. So it's not the work itself. Well, in other words, the derived work may not be a new work, but under the Canadian situation, it mentions the existing market and the potential market, but option 4 is silent on this area. Now, option 4 only targets the financial implications, but the Canadian option talks about other implications as well. And there are other areas. I only mentioned the major differences. So option 4 is even more lenient than the Canadian option. Now, and does it really fulfill or meet the three-step test? I think that deserves further thinking and consideration. Now, thank you for your detailed explanation. Now, whether you're talking about options 1, 2, or 3, or option 4, and including the Canadian option on UGC, these are not tested by the international authorities. So with all your consultation, we could one day find ourselves unable to satisfy the legislative requirements. Or I think, well, I used up my time because the answer given to me was very, very long. Okay, now for secondary creation or parody, now why they became a problem is because of the development and the popularity of internet use. Now, before the internet days, if you want to do parody or to spread your parodied work, it's not going to be that easy, and the number of people you can reach is very limited. But with the internet, well, let's put it this way, there should be a new set of regulation, but things are only just developing. Well, in the Snowden case and before this case, nobody knew that the US government was monitoring its own citizens as well as citizens in other jurisdictions. So before the internet days, we are not going to face such a problem. It will be very expensive to send, let's say, a satellite over somebody else's place to monitor the situation. So the US issue is still ongoing. There are still litigations. So what I'm trying to bring up is, because we're talking about a new virtual world order, can we, Hong Kong, take the lead, or are we going to follow other people? Now, with a population of 7 million, we have no need to be a pioneer in this regard. Okay, we don't want to lag behind, but it is not realistic for us to assume a leadership position. Okay, we may have some parity, secondary creation, but these are not limited to Hong Kong. There are similar situations elsewhere. And that is why in the consultation you have got a whole range of suggestions. So now, where should we base ourselves? Now, my question, Mr. Chairman, I'd like to ask about Appendix 3, but some members already asked the question, and we heard from the government what the Canadian government is doing and so on. Now, we mentioned the WTO, okay, but what other platforms can Hong Kong join to probe more deeply into this regarding this new Internet days, or its new order that the Internet is bringing in? And which international platform have we already joined or going to join? Now, the Internet does not really fall under our ambit, whether we have joined any international organizations. But if members are interested, we can ask the government information officer, colleague in a different bureau, and we can answer members' questions. Now, I agree that in the present round of consultation, it's unlikely that we can handle all topics or issues. There are still things developing elsewhere, and we have to wait until some sort of consensus is arrived at in the international arena. So we are going to use what we have, the precedent cases that we do have, to try to tackle the issue from there. Now, Chair, now let's limit ourselves to just parodies. Are there international platforms that Hong Kong is a member of? Now, for international or for intellectual properties, of course, we are a member to the World International Intellectual Property. We are a member via China, China being the sovereign state. And also under WTO, there is also intellectual property treaty, and there is a regular meeting discussing these issues, and we are a part of that. Next, we have Mr. Chung. Now, we've heard from the Secretary that our present legislation on copyright is lagging behind others. Now, what is your goal? You want to finish it in this legislative year, and we can work backwards. So when is the latest date to submit the amendment to us? And now, as to how we want to narrow it down, you have to update the legislation, because if we are lagging behind too much, we cannot make any progress. So what is your goal regarding the timetable? Okay, it's a similar question on timetable. Now, I have explained to members that we have no planned timetable as yet regarding parity. Now, if in the 2-3 months ahead, if we can get some sort of consensus, then we will be able to handle the consultation which we started way back in 2006. Now, this amendment, in fact, in the last round of LegCo, it was debated already, and we have continuously received feedback on the amendments or the proposed amendments. Now, in the coming days, Now, as we said in the paper, some have to do with safe haven and so on, not directly related to parody, but whenever we have received any such information, we will follow this up. Now, Mr. Chung, your question about whether we have the goal to finish the job in the legislative session, I have to say that I cannot tell you in any certain way. Okay, this may well be my goal to finish it, but I cannot promise you anything at this stage. Emily Lau, I hope this is not your Christmas wish and you have to rely on Santa Claus. Now, I think we all want society to have some sort of consensus before we move forward. Now, we know that the trade wanted to have something concrete, and so is the rest of society. Now, you have done your level best. You have meetings, and I have talked to the secretary that you should have more meetings, more consultations. This is true not only for your bureau, but also other bureaus, because when it's something controversial, you must talk to the stakeholders, and you will continue even well, during Christmas or the New Year. Now, you have answered the question already. In fact, I don't believe we can have well, consensus for everything, because some people believe you can do anything in the internet and nobody can stop them. Now, apart from those areas, are there other really difficult areas that you have identified? Now, we're looking at an international global society. In the most open societies, how do they do things? Because we want to identify ourselves with them. And there are some requests which nobody else is doing. And then if other jurisdictions can do things and then they can have good business, then we should learn from them. Chair, now, Ms. Lau's question, if I may come back to a question. Now, for Australia, they have got a fair dealing exemption for Australia, and a similar one exists in Canada. And on top of that, they have the UGC exemption, and Canada is the only jurisdiction that has this. The UK is doing something similar, which is in fact a fair dealing for parody. So whether we have precedents from the international arena that we can learn from. Now, if you look at Commonwealth jurisdictions across the globe, they are doing well, fair means exemption for parody. But we are dealing with not just parody. There are other areas such as, or we should expand this to secondary creation as well as UGC. So if you're going to have an exemption, how wide is it going to be? So you have views from the Bar Association, Law Society, and even they do not see eye to eye. Both have proposed a fair means criterion to handle parody, satire, caricature, and pastiche, and not to the extent that some netizens propose that all secondary creation and UGC are to be exempted. Now, these are things we want to know more in the coming weeks, and how they are going to be handled. Now, if these can be done, then we don't have to broaden the issue. So I have to see whether we can succeed in the coming 2 or 3 months. Now, I have a lot of confidence in the Secretary and his colleagues. Okay, there are things which are tough to handle, apparently, but I fully support them, the Secretary and his team, to continue with communication and all of us being reasonable, if you can have a consensus of some sort, then it will be a good thing. And you can come back to us with something pretty, solid or sound. Now, you have heard that most of us are giving you a lot of support, and we have a lot of faith in your work. I hope you will continue to get the biggest consensus to help us move forward.
Second round, we have Charles Mock. Anyone else? The time is almost up. If not, I'll draw a line here. Mr. Mock, thank you. I want to make some comments. They're not really questions. To supplement what Mr. Wyckoff said, he mentioned about some international organizations on this issue. I have attended one. It is an international forum under the UNESCO. There is also participation from the community and also from governments. In November, there was a meeting in Indonesia. 3 or 4 years ago, when I went to a forum, that was the only time when our government attended. That was the OGCIO. I don't know why no one was sent. No one has ever been sent apart from that time, because it is under your purview. It's related to copyright, but there is it's not like WIPO. There is nothing to be signed. So you mentioned WIPO. Well, it is mainly under their purview, and I agree with that. Please don't wait about legislation. Well, some people talk about UGC, and there are new developments in the European Union. It's just like buying a mobile phone. You wait, there are always a new model coming up. And nowadays, information is transparent. Anyone can go on the internet to find out what is going on in overseas countries. If you want the latest version, then you're always chasing your tail. So we don't be happy that you are a follower. Well, netizens are very smart. They will always find the latest version and ask why we're not doing it. So you need to make a decision to legislate. And if you want to use the latest version to convince us, you will never succeed. Just use one that is good enough. And that is one of the reasons why our legislation is rather outdated. And that's why everyone's asking about your timetable. P.S. Hopefully, when we introduce the amendment, well, I am aware of what Mr. Mock said. When we come up with a proposal, there will be new development elsewhere. And I hope members will understand this. At one stage, we will have to make a decision. Otherwise, we will always be using an old mobile phone that's 30 years old. Well, I'm sure you have heard members. Yes, the views are quite polarized. And I hope that after the informal discussion, you will be able to narrow the differences. Yes, we will revert to the panel. Hopefully next time you'll be able to give us a timetable. Thank you. Next is item 5. Proposed creation of one supernumerary post of Assistant Director of Intellectual Property in the Intellectual Property Department.
我哋喺度歡迎政府嘅代表知識產權處嘅處長張錦輝先生，知識產權處助理處長曾志深先生，商務及經濟發展局副秘書長黃福來先生，同埋商務及經濟發展局首席助理秘書長蘇貝善女士。處長係咪你？
We have with us Mr. Peter Zhang, Mr. Thomas Zhang, Mr. David Wong, and Mr. Ms. Patricia So from the IPD and the CEDB. Please take us through the paper. Yes, we would like to create a supernumerary post of Assistant Director of Intellectual Property, DL2, to carry out the works related to the implementation of the original grant patent OGP system and strengthening the promotion of Hong Kong as an intellectual property IP trading hub. In February this year, the government announced the future development of OGP, and is supported by DCI panel, and we hope that wherever we can, we will devote resources to make the applications to put in place this system. The setting of the OGP involved are lots of resources and planning, because we have to put in place a legislative framework. We have to strengthen the functions of the IPD. We have to increase manpower, upgrade systems, etc. Well, depending on the progress of the development of the system and the legislative framework, we hope that we will be able to have the OGP system and the refined short-term system in 2016 and 17. With the OGP system, we will be able to promote Hong Kong's interests in the long run. We hope that Hong Kong can be turned into a regional IP trading hub. Secretary for the CED leads a working group on IP trading, and this working group was set up in March this year. After 3 rounds of discussion, there is a strategic framework to promote the development of Hong Kong as regional IP trading hub. This covers 4 areas. First, to enhance the IP protection regime. 2, support IP creation and exploitation. 3, fostering IP intermediary services and manpower capacity. That is in coordination and to enhance the quality of the manpower pool. And the 4th one is to pursue promotion, education, and external collaboration. Next year, the working group will have to explore specific focus strategies and formulate an action plan. They need the support of the IPD, which will conduct the researches and to seek to give a legal and policy advice, to liaise with stakeholders and to promote and educate the community, and at the same time to cooperate with external parties. So we need to create this assistant director post of the IP because of the formulation of the OGP and to refine the short-term patent system and all the relevant work. So they are all very complicated. There are 4 ADs in the IPD, 1 responsible for registration, 1 for copyright, 1 for tribunal, and the other one for legal hearings, and 1 for advisory. And so there is no extra manpower to take up the additional work. So we would like to create a 3-year supernumerary post of assistant director to take up the additional work under the new policies and initiatives. So when it comes to formulation of logistics, the information technology system and legislative amendments, the formulation and the examination of manual, promotion and publicity campaign, etc. All these are long-term work. Is long-term work. So this is a supernumerary post of 3 years. Depending on the need, we will at the right time review the situation to see if there is a long-term need. We hope the panel will understand that the administration, especially the IPD, will have to take up new challenges and extra work. So there is a need to create this post. Thank you. Mr. Wong Ting Kwong and another member would like to ask questions. The DAB has always supported the development of intellectual property and its trading. So the creation of this post is supported by us. We find it strange that it is a supernumerary post of 3 years and not a permanent position. Is it the case that in 3 years that will be the end of such development? And why is it supernumerary? Why not a permanent post? Because we would like the development in this area to continue and strengthen. What will happen in 3 years' time? So is it an open recruitment or an internal promotion? And I have another question. Did we try to get mutual recognition with the mainland or other economies about the OGP system? Any progress? Director, I thank the member for his question. First, IP trading is right. IP trading is very important to Hong Kong. It's a long-term strategic development. And when it comes to our establishment, the stance of the administration is cautious and pragmatic. Depending on the development of the situation and market development, it may change. So we would like to do it for 3 years for now. 3 years down the line, if there is a need, we don't rule out the possibility for doing something else. So does it mean that you're not confident? We are confident and we are determined. It's just that we are cautious and pragmatic. That's what we have in mind. I hope members and chairman will understand that we would like to take one step at a time and be pragmatic. What about mutual recognition? We understand that this is the aspiration of a lot of bodies. We have to first increase manpower. There is already a team. In October this year, through internal deployment, we have formed a team to take up the work. The establishment of a patent system involved a lot of resources, IT system, dissemination of information, etc. We have to establish a structure that is in line with international community and SIPO, the State Intellectual Property Office. So depending on the situation and the time, we will continue to liaise with SIPO to explore the possibility of mutual recognition of patent. Mr. Charles Mock. Thank you. In relation to the patent system and IP trading developments and discussions, we think that the discussion with the IT sector is insufficient. Very often we don't know what's going on.
very often you have one party moving ahead first, and the IT field only informed at a later stage. And this is not the best way forward. Even though you say that you are doing this to support new technology, we are not expert in the legislation side. But then there are other factors that have to be looked at together. So during the creation of a post, I think we have to make it known that this should be handled better. Now, if there are members representing the IT field, but then they are not liaising with us and we have been kept in the dark, so the department can, well, consult the trade and work together. Now, even within department, if you look at the IT office, now what is their policy? Now, they actually affect the IP development work. So even at a very early stage, the various parties should work together. So this is just comment given to you, colleagues. Now, for the creation of the polls, I feel this is important work to be done, and I would support the creation of the polls. Now, we have looked at the table as to what work will be done. Now, I think you can add in communication with the trade as being one area of work. This has to be strengthened. I know you have touched on this in the paper, but I think in actual fact we'll be able to see this implemented. Now, thank you, Mr. Mock, for your reminder. Now, on this OGP and other areas, we have actually conducted consultation, and we have then made known the public to the public, and we have got committees from with representatives from various sectors. So we agree with your view that we have to step up a liaison with the various stakeholders. So with the creation of the post and with the additional personnel, we'll be able to keep in touch with the sectors, and on the whole it's going to benefit all of Hong Kong. We have Madam Cheung. Now I'd like to ask the director, you have 3 ADs helping you, is that correct? Yeah. And I know you have a lot on your plate. Okay, you have 1 DD already, but is it the case that this is something you already have in place? Yes, for 6 months we have 1 for internal deployment, when we can have AD at a DL2. We are now asking for a supernumerary one starting from April 1st next year. So I see. So that's why Mr. Mock was asking the question. So you coming here only for 3 years? Now, because for IP it's not for a period of 3 years. It should be much more longer term. Now, at the AD level, a very senior level, you cannot tell the person, okay, you are here only for 3 years, and then you will lose the job, and he or she wouldn't know where he's going, because it's only a supernumerary post. So I'm suggesting that this post be longer term. Now we have this copyright system in Hong Kong. I don't know how to put it when we are talking about to approve patents. Now, it seems that we are not quite able to do the work. If, let's say, I have an invention of some sort, I want to register this to be patented. Can we do it now? Yes, you can do it now. Yes. Yes. Let me supplement, Chair. Yes, under the existing system, if you have an invention, you can apply for a short-term patent to coming to our registration office. So that's one way. The other way is to apply for a standard patent, which will cover you for 20 years. In our case, it's 8 years. But because of historical reasons, you have to go to the UK or other parts of the Europe, or after the handover, you can go to China to initially, and then come back to Hong Kong. Now, we are going to enhance the original grant ability so that we don't have to rely on other patent offices, so that we can actually do the work ourselves. Okay, I understand. So you cannot really say that you have the approval authority. Well, you can say that we have the protection system, not really the approval authority. Okay, you have the invention, you go there to do registration. You cannot do it. You have to send me to the UK and then coming to us. If it's for a short-term one, then that is okay. You can come to us. Now, okay, you have been telling us that you want to do things gradually, Director, one step at a time. Okay, this is good. This is to be pragmatic. But are you going to have a whole approval process instead of having to send us to Beijing or London? Because even Macau now has its own IP now, but it has to work through an IP department, and they have to work through their own legislation for the SAR. But we are now talking about an OGP system. We want to establish this as well as the manpower needed. So in the longer term, for specific areas, we'll be able to have this local OGP system. Now, coming back to this new post now, and on the development of IP, or developing as a trading hub with our own approval system or some sort of an OGP system. Now, I believe all these will help with the economic development of Hong Kong. Now, I understand that this new post is to support the IP plans. Now, I'm sure you have some sort of plan in the pipeline. Now, can you tell us a little bit more what the new post or the proposed post will accomplish? Yes, thank you, Madam Chang. Yes, for your suggestion. Yes, we will look at the actual market need regarding the length of the post. Now, we welcome your concern about our creation of post. Now, this new AD post will help with the working group on IP trading. It will provide support because the work is getting more complex. Now, the latest meeting in December, the Trade Development Office, now we have we're seeing more and more people from 700 to 1400 to 2000. So for Hong Kong working as a hub, we are playing a more important role, not just for Hong Kong, but for the Asia-Pacific region, China, and the rest of the world. So if members support the creation of this supernumerary ADIP post, we believe that this will help with the spreading of the work, the legislative framework creation, and we believe we will generally do a much better job. Madam Zhang, can we arrange a meeting so that we can discuss with the IP department so that we can know more about their work? Because I understand that you have heavy responsibilities, so we as members must know more about your work before we know how to support your work. Because our status being changed from manufacturing hub to IP hub or more on the economic side. Now I believe that we members should know more and not necessarily confined to this meeting room because time is so limited. Okay, we'll let the Secretariat arrange something for us, or maybe we can pay a visit to their office. Yes, you're most welcome. Yes, our working group has started some general meeting on this, but we're most happy to do more. Now it seems to me that most of us are in favor of the creation of the post, and they are just being pragmatic, limiting themselves to only 3 years. There is a chance that they will come to us again and to turn it into a permanent post. Yes, I believe this is an important post, and members here are supporting this particular proposal. Yeah, thank you, members. Next, we are moving on to agenda item 6. That is AOB. If you don't, I have one. Last time, a member suggested doing an overseas study tour on the latest technology. I have asked the Secretariat to identify 3 places, and they are South Korea, Israel, and Belgium. Now, the research department colleagues have done some work, and do we have anyone from the research section? Is it a Madam Wu? Madam Wu, can I ask you to tell us what work you have done for the 3 countries? Yes, Chairman. Now, at members' request, we have done something on the IT industry in South Korea, Israel, and Belgium. Now, allow me to very briefly describe what they are doing in the IT field. Now, first of all, South Korea, it lacks natural resources, so in order to pursue economic growth, it's developing its human capital and investing a lot in IT. And way back in the 60s, they began to import foreign technology, and in the 80s, they do more on research and development. And now in 2011, their expenses overall is 4.03% of its GDP, which ranked the 6th highest in the world. And in 2013, it ranked 18th in the Global Innovation Index.
The main advantage of South Korea in the development of this industry is of its sound infrastructure, including the infiltration rate of broadband and the internet. And they have a highly educated workforce, and there is strong support on the development of IT. There is information, communication, LCD, semiconductors, some medical biological technology. They are all very prominent. I don't mean to interrupt you. Last time there was a suggestion to do a duty visit, and those members say Sin Chung Kai and Charles Mock, they're not here. Instead of asking Miss Wu to waste time. No, but they already have the information. It's been sent to us. There is... Well, please give us a paper. Oh, there is one. We don't want to waste Miss Wu's time and effort, because the members are not here. Perhaps we will revisit this next time and discuss it in the first agenda item. That is the policy briefing. It doesn't matter. It will be quick. It will only take 10 minutes. Because it will be a waste of Mr. Wu's time and effort. Because the members are not here, and she's done a lot of things. There's no one here. Well, we are people. But there are some members who would very much like to have an overseas duty visit. I agree with you. Yes, that will be the first item in the next meeting. It shouldn't take up too much time, and then there will be a presentation, a decision made. Yes, that will at most take 8 to 10 minutes. Do you agree? Yes. Miss Wu, next time you will present your work when there are more members in the room. Well, that being the case, there are no other business. I wish you all a very healthy and happy Christmas.